All right. Welcome to episode 93 of the Jake Blanchard podcast. I've got Rich Goldstein today. He's a patent attorney, entrepreneur, author, speaker who helps people protect their ideas. He secured more than 2,000 patents in his career and is an expert in protecting intellectual property. He's also the author of the American Bar Association's Consumer Guide to Obtaining Patents. Rich, welcome to the show, man. How are you today?
I'm doing great. Thanks so much for having me, Jake.
Dude, of course, man. I'm, folks who listen to the show know I'm kind of I'm generally a pretty curious individual. Your area of expertise is something that has been more recently near and dear to my heart. I've got a couple of clients that are really focused on patents, and personally, I've got some things that I've got to protect as well as far as intellectual property goes. Things like this podcast and some of the logos and things around my business ecosystem as well. Before we dive too deep here, man, what attracted you to this legal space in the first place, man? How'd you get into law, and then how'd you get into specifically patents, trademarks, copyrights, those types of things?
Yeah, well, I mean, it pretty much goes back to college. I was studying electrical engineering, and I got interested in business, and I wanted at one point to change my major from engineering to business, and then also at the same time, I learned that the reality of being an engineer would be that you work on the same project like day in and day out for years at a time. Some little piece of some system. They're like, here's your inputs, this is the output. Now spend the next 5 years designing what goes in between. And this just did not fit for me. And again, like I'm interested in business, interested in doing something more than just kind of working on one little thing at a time. And I learned about patent law, where in order to be a patent lawyer, you need to have a science or engineering degree, and then also go to law school. And so that's what I did. I finished up electrical engineering. I went to law school and became a patent lawyer. And now I work on something different every single day.
That's a great kind of entry point for us here. I can tell you that, like, as an outsider, like this area seems kind of overwhelming. Like, unless people have like a real reason to go out, like unless they're an inventor or they're interested in inventing a product, or they came up with a really cool name that they want to protect, most people don't think about patents and trademarks and copyrights and those types of things. So when we talk about that ecosystem, you mind helping us like anchor in what is the difference between a patent and a trademark and a copy, just to get us started here? And then also, I hear the word trade secret, and then is that part of the whole thing as well?
Okay, let's unbundle that. But let's start with where you started here. So saying that essentially it's you have ideas, you've created stuff, but IP, intellectual property, is kind of overwhelming. And so you do what many entrepreneurs do, or I actually don't know exactly what you do about that. But the point is most entrepreneurs feel overwhelmed by it, and it's what keeps them away. It's like, I'm not going to bother with that. That's just too complicated. Like, let me focus on getting my product out there. Let me focus on building my business. And I would venture to say that for entrepreneurs, that IP can be the thing that you know the least about, that could have the biggest impact on your business if you just learn a little bit about it. Because it really is like, it's the complexity that scares people away. But sometimes just a few principles are enough to steer you in the right direction, have you pursue the right IP at the right time, not waste money on the wrong IP at the wrong time. And so that's why I'm really passionate about educating people about IP, educating entrepreneurs about IP, so that they make good decisions when IP opportunities come up. So there's that. So I just want to presence that. And like, I really appreciate you making this the subject of this episode, because again, it's the type of thing that could make a big impact for entrepreneurs, to just understand a few things, to dispel a few misconceptions, because those misconceptions can have people waste money on IP when they shouldn't be spending it, and have them scared to take action when there is an opportunity that they should be pursuing and protecting. So there's that. And now going to your question about patents and trademarks and copyrights and the difference, and then And then the bonus question about trade secrets. So patents, trademark, copyrights, they each protect different types of things, different subject matter. So if we're talking about a product, like a product idea, like the structure of a product, the design of a product, then we're likely talking about a patent. If you're talking about branding, if you're talking about the name of a product, the logo of a product, the color scheme on the product, the type of things that people, when they see it, they think of one company and one company only, then that's a trademark. You know, that could be like the name Coca-Cola or the swoosh for Nike,
or the Jake Blanchard podcast.
Say that again.
Or the Jake Blanchard podcast.
Yeah, exactly. That could be a trademark, because if people saw a podcast with a similar name, they might be confused and think it's affiliated with you. And so yeah, any type of branding, that's where trademarks come into play. And then lastly, when it comes to content, that's where copyright is involved. So content could be the content of a book. It could be the content of a web page. It could be the content of a song, like the musical composition of a song. Those works of content are what's protected by copyright. So to break it down simply, it's products, patents, content, copyrights, and branding, trademarks.
So then, when I said things were kind of scary for entrepreneurs, or it's overwhelming for entrepreneurs, I think the thing that is the scariest is the cost associated with setting this up. If you're to make a case then for an entrepreneur who's looking at all the different things that they have to set up, right? It's like, man, I got to do the website, man, I've got to do maybe hire a couple employees or buy inventory and all these other things. What is the case to say, like, one of the first things that you should be doing is protecting your intellectual property in this way? Or like, where
first of all, I wouldn't say that.
Oh, perfect. Yeah, that's what I'm hoping to.
I wouldn't make the case that the first thing you should be doing is protecting your intellectual property. I would say one of the first things you should be doing is exploring whether you should be protecting your intellectual property, because there are some examples, especially when it comes to patents, that you will lose the right if you don't pursue it at the right time. But much of the time, it doesn't pay to really invest into IP at an early stage, or at least into patents at an early stage. And I'm a patent attorney. I make my living by doing patents, but I'll tell you that for most entrepreneurs, you should not be doing a patent when you're starting a business. You should be focused on other things. But if you look into it and you discover, wow, this is a real good opportunity here to get a strong, valuable patent, then maybe you should be allocating resources to it. So what I'm going to make the case for is to look into it and decide whether this is the right opportunity. I mean, for many people, even companies launching products, they might have their first product and say, you know what, I got to do a patent because people are telling me I have to do a patent, and they'll spend a lot of money on the patent, and it won't really do anything for them. And then the second product comes along, and then the third product comes along, and they don't patent it either. And so at that point, though, maybe that third product idea is the one that they should be patenting. But already they feel like, I spent money on patents before. It's not really worth it. So I don't want entrepreneurs to burn out on an IP. I want them to know enough to know when they should pull the trigger on it and when they should focus on all the other things that they ought to be doing and spending money on when they're launching their company.
So well said. So then it's one of those things that you should be asking the right questions, but it's not one of those things that like is a prerequisite to running a healthy and successful business, that you have to have all these, intellectual property measures in place, in all cases. Right.
Yeah, exactly. It's not a one size fits all. It's more like kind of knowing when it's something that you ought to pay attention to.
Sorry.
Yeah, go ahead.
Yeah, I was going to say one of the things that surprised me as I was preparing for this was I was trying to get a feel for, how many patents actually get issued in any given year. And I was actually surprised to see that there's over, it looks like every year there's at least 500,000 to 600,000 patents that are at least filed. And then almost 50% of those, it seems, for utility patents are issued.
Mhm.
Is that 50% seems pretty high to me. I would say like every time I think about patents, I'm like, I feel like there's like an adversarial relationship between whatever patent office is like trying to, you know, make decisions on it, and things are getting rejected all the time and this and that. But
Mhm.
it seems like there's a lot higher success rate than I guess I really anticipated. What your thoughts on that? And has that changed over the years?
It's increased over the years, and the success rate, so to speak, has swung back and forth a little bit, within, maybe 10 or 20 percentage points at different times. Um, but yeah, I mean, it's fair that about half of patents are approved, because here's the thing, that there are some patents that are worthwhile and some that are not. And I think that's part of the magic of what entrepreneurs need to understand about whether when to do it or not. Because most of the time, people think of patents as kind of like an absolute. Like they see a product with a patent number and they're like, oh, well, that product's patented. Guess I can't make that. But the patent doesn't protect the product. The patent protects something about the product, some combination of features, something about it that was unique. And that's what the patent is protecting. And so here's the thing. And again, it's like you have people with two very different schools of thought about this. There are some people that will say, patents are so valuable. You have to do a patent. If you're going to launch a product, do a patent, do a patent, do a patent. You'd be crazy not to do a patent, right? And there are other people that say, don't bother with patents. You change one thing and you get around the patent. It's not worth it. So the question is like, well, which of them is right? And the answer is that they're both right at different times. And what it comes down to is this one very simple principle. It's that you can get a patent that is as broad and covers as much of a new concept as doesn't already exist. But most of the time, there's way more that exists than the inventor even knows of. So then it gets relegated to focusing on some details of it that make it different. It's like maybe about like at the very beginning of my career in the early 90s, there was a really hot idea that all patent attorneys, I can't imagine that you could be a patent attorney and not have someone come into the office with this one. It's like a remote control locator. So something to help you find your TV remote control when it gets lost in the couch or whatever. So so you had all these guys who had this idea of a remote control locator. And they go to the patent attorney and they said, I've got this idea for my remote control locator. And then, oh, how does it work? Okay, well, the way it works is that you put this little thing on the side of the TV and you stick it on there, and then you stick the thing on the back of your remote, and then you press the button on the TV when it's lost, and then it starts beeping. And then it keeps beeping for about 5 minutes. And if you don't, find it and reset it, it will beep again for another 5 minutes. Okay, great. So then patent attorney does a search. They say, wow, look, there's lots of remote control locators out there. And they tell the client, well, you can get a patent on this. The person's very excited. Oh, that's great. I can get a patent on this. Like, let's do it. But really, the reason the patent attorney says you get a patent on this is because he said, well, yeah, none of them have this thing that you stick on the TV, stick on the remote, you press the button, and then it makes it beep for 5 minutes at a time. And then if you don't reset it, it beeps again a few minutes later. That level of specificity might have been required to actually get the patent. So then what happens? The person has they get their patent approved. They're all excited. They're hanging up on the wall, and then they see someone else has a remote control locator. It's like they stole my idea. And then they bring it to the patent attorney. And the patent attorney is like, well, yeah, but like theirs doesn't beep for 5 minutes like yours does. And then the person says, see that? They changed one thing and they got around my idea. And the lesson is that the inventor didn't have a patent on what he or she thought they had a patent on. They don't have a patent on the idea of a remote control locator. They have a patent on the fine details about how theirs worked. They didn't understand that. So when they saw another remote control locator out there, they thought that person was infringing their patent. And so this is the thing that entrepreneurs don't understand about patents, is that every patent has a scope. Every patent has a range of what it protects. And that could be a big range as we would hope it to have, where it covers a whole new idea. But if your idea wasn't that new to begin with, then it's going to cover a rather specific version of it. And then people making changes to it, or they don't necessarily have to do it exactly like you did, then it's not a very worthwhile patent. And this is why the important thing is at the very beginning is not to just jump in and do a patent, but to figure this thing out. Is not just, can you get a patent, but if you were going to get a patent, what would it cover? What is the thing that makes yours new? And then, is this thing that makes yours new, is that what the market cares about? Is that what your customers care about? Is that what people would say, hey, I want that product, and unless it has that thing, then I don't want it. And therefore your competition doesn't even want to bother trying to copy it, because they can't make it without the thing that everyone wants. And that companies want to license it from you because it's that thing that you have the patent on that makes that it has all the magic to it.
The special sauce.
That's what you're looking for.
It's that special sauce, right? It's that you just don't patent it just to patent it, is what I'm hearing. It's like it really needs to be that special thing that
when the special thing is unique.
Yeah,
right, exactly. And that's what most people miss. And that's where you talk about having like hundreds of thousands of patent applications filed every year and half of them granted. Yeah, they can be granted if we narrow them down. And a lot of companies are happy to get portfolios of thousands of patents. Many of them have limited value. But that's kind of the answer to all of it right there, is that understanding that every patent has a scope or a range of what it protects, which makes some of them worth a lot and some of them worth very little. Then that's really the key to understanding all of it.
Oh, for sure. And Rich, I mean, one of the things that I'm particularly interested in is the patent offices, as I understand them, are different in each country. And then, so like you've got some patents that you have to file in multiple countries. I guess you plan on doing business there, or like if you sell a product in a certain country, like there's risks of it being reverse engineered, and maybe that, there being some kind of like international infringement, and what is that recourse then, if you're going to be litigious about it. Like, maybe help me understand the impacts of international copyright or trademark or patent infringement, and what you've seen.
Okay, well, they're all a little different, but if we
sure.
focus on patent for a moment. So patents, it's jurisdictional. So if you want protection in Japan, you need a Japanese patent. And by protection, I mean, it's generally making, using, or selling the product within the jurisdiction that causes patent infringement. So a lot of times, you have in mind that you're going to sell your product in the US, but maybe it's going to be made in China, and you're concerned that maybe someone else will make it in China and then bring it in. Well, your US patent would prevent them from selling it in the US. But if you're concerned that maybe there's a market for your product in China or in South Korea or in Europe, then you'd want to file patents there. And it gets very expensive. And so that's the critical consideration, though, is you want to determine whether there's a market in those places before you apply for a patent there. And then the one other little secret to it is that you get a year. So once you file in the US, you have a year to continue the process internationally if you want to. So a year to kind of go out there, try to get some traction and see how things are going, and see whether it's worth diving further into filing in other jurisdictions.
All right. So then you've got a little bit of latitude then if you want to explore internationally, and maybe, I guess, at least delay the cost.
Exactly.
And then that's a year from when you submit. It's not a year to get approved on your international patent, right?
Right. It's a year from when you submit. So from when you exactly, if you wait until the patent's approved, it will become too late to apply in other places. But 1 year from when you submit, you can still file in other countries, um, and uh, and that's how it goes with patents. With trademarks, it's a little different. Within 6 months, you can claim priority. Let's say to your U.S. application, you could do in multiple countries. The big difference between patents and trademarks in that regard is that trademarks are a lot less expensive. Trademarks, like whereas utility patent could be like $15,000, let's say, trademark maybe a couple thousand. And so then filing trademarks in multiple countries would cost maybe a couple thousand more per country, but not dramatically more like patents may cost. And then just to close the loop on that too, with copyrights. With copyrights, it's more automatic protection around the world through most of the world. It's something called the Berne Convention, Berne, which kind of lateralizes copyright protection throughout all of the member states. And I think there's roughly 100 countries that adhere to the Berne Convention. So copyrights are a bit more automatic. So that's how the three work internationally.
Yeah, and then as I was kind of kicking the tires as well on this topic, I realized that like there's a multi-billion-dollar industry in brand protection out there, like from a internet standpoint, folks that are just scraping pages all the time looking to see for any unlawful use of trademarked materials. Yep. And things like that. I mean, I imagine someone like yourself who's been doing this for between 25 and 30 years, something along those lines, like you've really seen the technology play out here so that you can really identifying who is infringing. Like, what are the steps then? You find out somebody's infringing on the technology and then or on your trademark, and then what do you do? Like, how do you make them stop?
Yeah, I mean, it could be complicated because in general, going to court can be extremely expensive. So then you look for lower cost alternatives in terms of maybe contacting them and seeing if they'd be willing to stop. But there's a real hazard to that most people aren't aware of. People think, well, if someone's infringing, I should just send them a cease and desist letter. And they're like, well, I don't have $100,000 spent on litigation, but I could pay a lawyer a few $1,000s to write a letter. The problem is, if that's your situation, then it's dangerous to send a cease and desist letter, because when you send a cease and desist letter, you might end up getting sued. It's like you telling someone, hey, look, you're infringing my trademark, you're infringing my patent. They have a right in many jurisdictions and many circumstances to be able to clarify that. It's like, well, we don't think that we are. And you know what? We can't have this hanging over our head. We're about to invest millions into additional orders of products, blah, blah, blah. So they can bring what's called a declaratory judgment action to get the court to declare that they're not infringing or declare that the patent's invalid. And if you're the person who sent the cease and desist letter, you might find yourself suddenly in the position where you're in a lawsuit, even though you had no intention of paying for one. So there's that. There's also various platforms where the procedures are simplified a bit. So like you see someone infringing your patent or trademark on Walmart or on Amazon, there are some internal procedures where you can make a complaint and it could be dealt with without having to go to court. So that's some of the mechanics of it. But I think like one of the principles behind it is, if you have a trademark, you need to police your brand. So like, if you having a trademark means that you're saying that when people see this brand name, they think of my company and my company only. But if you allow people to start to use that brand name such that no one's really even thinking it's necessarily you anymore, like there's 3 different people that are using this name, then you risk losing the ability to protect your trademark, or even like possibly losing the trademark itself. So it's like, you need to maintain, you need to police your trademark. You need to maintain clarity among consumers that there's one and only one company that sells sneakers with a swoosh, on the side of the box.
Yeah. Yeah. And continuing to go down the world of, I guess it would be trademark, maybe copyright. Help educate me here. Like, do NFTs fit in this world at all? Are you paying attention to the NFT world and what the impacts are for trademarks or copyrights or whatever it would fit into?
Yeah, well, I think it's a little early to know exactly how it's going to impact things, except, here's the thing about stuff, on the blockchain, things related to, NFTs and such, is that people like to think of it as like, well, it's the Wild West, right? There's no rules. You don't have to follow the rules. And so, uh, and you can get away with anything, but the rules still do apply. If you take someone's brand name and you turn it into an NFT, it's still infringing. If you take someone's image, like people like to make these kind of pop art type items with like existing image and then like, making it an NFT, coloring it and then making it an NFT and saying like that's my NFT. It's still copyright infringement. So it's like just because you're on the blockchain, just because you make it an NFT doesn't mean the rules don't apply anymore. And then the other part of it is that people think you can get away with anything on the blockchain because it's anonymous. No, everything is tracked. Everything is tracked to the nth degree. Like you can, any transaction that takes place on the blockchain, it's recorded in thousands of places. And so, yeah, I mean, you could do things anonymously, but then the moment that you try to cash it into some real world service or convert that the coin into currency, then it's obvious it's connected to your bank account or to you. And so it's like I've heard kind of investigators from the federal government talk about this, like how easy it is to pursue like tax evasion, what's on the blockchain and such, is that because it's all right there. All the records are just open for anyone to see. So
That's
uh
wild.
so then circling back to this stuff though, it's like, yeah, it's like the rules still are the rules. As much as people would like to think I could just use Nike trademark and make it my NFT, like no, like that's going to catch up with you. I don't think anyone is quite sure how how to enforce things or what mechanism they're going to use, or like the enforcement machinery hasn't caught up quite yet with taking action and coming down on everyone. But yeah, the rules still do apply. And ultimately, if you cash out on anything that you've done on the blockchain, it's traceable to you.
It's a crazy world coming, man. I spend a little bit of time just trying to understand, what is this, right? This, this NFT world, this block, like what are the impacts of it? I'm wildly anticipating. Just I think it's still the Wild West. Like I don't know. It's gonna be hard to convince me otherwise. Like the innovation that's going to be spooling out. But to your point, there are rules, and I didn't really
Yeah.
think about it in that term. Is like the at least the standard rule set is already in place.
It
So
already exists, right?
yeah,
The rules already exist, and yes, there's huge opportunities there, and people are saying too that the the typical use case we see for NFTs, where it's like somebody had a picture of a monkey and they sold it for 100 Ethereum or like $400,000, right? That's what we see. That's what makes the headlines. But this is just one use case for NFTs. Like there is tremendously, it's tremendous opportunities for in all different realms. Like even just things as simple as concert tickets, where people have struggled for decades. Like, well, how do you get concert tickets where you could authenticate them so that they could be resold, and that you could kind of link it uniquely to the purchaser, let's say, until they resell it, and all of these different challenges in an area like that could be easily overcome with an NFT. And then even to have it unlock additional content, have it be an access to some type of membership. There are
Yeah.
all these opportunities that are and the surface is barely being scratched at the moment.
Absolutely. Hey man, I want to shift gears just a little bit. That book that you held up earlier in the show, the Consumer Guide to Obtaining Patents.
Mhm.
It's got that ABA, that American Bar Association branding right there on the top. There's got to be a story behind that, man. So how you know
Yeah.
how did you were you asked to write this book? Did you write this book and then it got endorsed by the American Bar Association? Like take me through that process, and how was it writing the book and who's it for?
Yeah, I was asked to write the book, and it's awesome, and like it really it goes back to 2012, 2013. I was doing a lot of traveling. I was going to a lot of events around the world. I think I was in Europe 6 times that year, going to different events and related to innovation and other things. And a lot of times I was at event and I'm meeting people, creating relationships, and people were asking me, well, okay, so you're a patent attorney. So like, why are you here? Like, in other words, what's the end game? How are you going to monetize this? And I didn't really know. I didn't really know how I was going to monetize like that, those relationships or that travel until one day, a couple of years later, I think it was roughly 2015, where I got a call from an editor at the American Bar Association. And he asked me whether I'd like to write a book for the American Bar Association explaining to entrepreneurs how patents work. And so, of course, I was like, yeah, like that's awesome. And so, inevitably, the question though is like, well, why me? What made you reach out to me? And what he said was, well, we look for author. We see that you've been out there going to lots of different events. Like I see on your website, you were at 26 different events in 2014. And what we want in an author is someone who is not sitting behind the desk, but who's out there meeting people and educating people. Like that's how we sell books. Okay, cool. So I didn't really know how that was all going to come back around. I didn't know, what the end result was going to be from all that I was doing there. But that's kind of how it came back around. It was part of the reason why the American Bar Association asked me to write this book. And it's kind of like my favorite notion of abundance is that you're not really you're doing your thing. You're not really watching your back to see that you're getting yours, right? You just
Yeah.
kind of have a trust that as long as you do your thing out in the world, that it will come back around to you. And so that's kind of a shining example of how that worked out.
Oh, 100%. I mean, I'm all about leading with gratitude and curiosity. And ever since I started like really being purposeful about that, I mean, it is always, I feel guilty sometimes. It's always returned back to me tenfold and in opportunities or conversations or insights. And, what an awesome way to operate. And clearly it found you in the right way. So feedback on that book, man. I imagine you've touched a lot of entrepreneurs that have probably reached out to you and said, hey, thanks for drawing a map for me.
Yeah. Yeah, exactly. And it's like because the way that the book is written is pretty much the way that I speak. It's just conversational.
Yeah.
Let me just tell you everything you'd want to know about patents if you were my brother-in-law sitting across the table from me.
Yeah. And then, so, you said the way that you speak, I know that you also, you have a podcast as well.
Mhm.
The Innovations and Breakthroughs podcast. Give me on the genesis of that. I mean, probably intellectually curious, bringing different people on. What are you talking about on that show?
Yeah, well, first of all, I'm talking about the path that people take, uh, starting from concept and then bringing it out into the world. Actually, just about 2 hours ago, I interviewed the founder of Uggs, and that's what we were talking about. Is like how he had this idea, had this notion, and it ultimately became $1 billion brand. And so those are the types of stories that I like to tell on the podcast. And I'll tell you something else though, just in terms of your question about what's the genesis of it. So the genesis is my friend Jeremy, who was encouraging me. Let's say, to put it mildly, he was encouraging me for a couple of years to start a podcast. And his notion always was, for those people who say, like, oh man, like I'm not sure who's going to listen to my podcast. You'd say, like, you don't really create the podcast for the people that are going to listen to it. It's like you do your thing and the audience will find itself. But what you will find is that you'll create the richest relationships just through reaching out to people and interviewing them for your podcast. Like that's where you really get the most juice is through the people that you meet by interviewing them for the podcast, and even asking people who would you recommend. And I imagine you find similar.
Oh yeah, I the types of folks that I've had the opportunity, like yourself, to be able to chat with and learn from, like some of the best that are in their either niche markets or have done some really great, interesting things. Yeah, I'm all about it, and I believe the same thing. The audience will find you. Uh, they'll get pulled into your gravity if you're consistent, if you're creating it, and if you're willing to be curious and have a meaningful conversation. So I think we share that sentiment as well.
Absolutely. And we're neck and neck. I think you I looked at, and you are on episode 92, I think, and I just put out 90
Oh, there we
today.
go. Yeah,
Yeah.
absolutely.
So we're neck and neck.
We're in there, man. I love it. So I'm curious. I mean, somebody like yourself who's been doing this for again 25, 30 years, somewhere in there, that you've been out in this field. Clearly you're an expert. Clearly you love the scientist side of it too, the mechanical and all this. What's been the biggest thing that you've seen change, especially in the US, around any of this that we're talking about, whether it be patents or trademarks, or just the thing that, like, when it changed, you were like, whoa, this is changing the game. This is different. Or has there been anything?
Okay. I actually the biggest thing I've seen change is writing ability. So and then this isn't a very sexy answer, but like when I started, all patent attorneys were excellent writers and wrote very concise and understandable explanations of what the invention is. And just the level of writing in my field has gone down tremendously. And the level of writing among law school graduates that I would hire has gone down tremendously. And it's like there's just as we've increased our communication, where we communicate with people through text and social media dramatically more than we did decades ago. Like the actual ability to take an idea and break it down simply in writing has really deteriorated.
Do you think it's a byproduct of intellectual laziness when it comes to communication, or the fact that we spend time using hieroglyphics to talk to each other half the time with GIFs and memes, or like schools aren't putting as much of an emphasis on it, families aren't putting as much of an emphasis? Like, where do you think that's coming from?
Yeah, I think all of the above. I mean, I think there is a de-emphasis on it as being an important or critical skill, and
Yeah.
schools are not putting the emphasis on it that needs to have. And people are kind of subsiding on simpler, more basic one-word communications. Um,
LOL.
yeah, I mean, I guess.
No,
I mean,
you know,
I sound like an old guy now making
I,
a comment like that. It's
I
like,
don't think
now,
so.
kids today, but
I actually really appreciate the insight. I mean, I'll put myself out in the open here. Like, I was an English major when I went to college. I was like, I'm going to college and I'm going to study some English, and I'll minor in business and something. And it took me like year and a half of being an English major to realize that I don't know how to read and write very well. Like, I just really didn't. Like, I didn't know, like, I'd get confused on the basics, adjectives, verbs, like things like that. And it's a direct result of how much emphasis I put on it. It was also, I got away with a lot. And then I even got away with a lot in college as far as my writing goes and those types of things. So conceptually, I find myself in a position where I understand a lot of things. I'm a terrible writer when it comes down to putting words to paper. So I think I'm in that generation of folks that you're talking about here that's de-emphasized it and totally owning it. But I don't know if I need to pick up a Strunk and White or whatever I need to pick up to to get my act together. Yeah. So how
Well,
does that
I
manifest?
would say it's just knowing that there's something more that you want in that area is all you need.
Yeah.
I think it's like I put out job request or a job ad, and the even the email that accompanies the resume, like it seems it's clear that the person who sent it didn't even care about expressing them, didn't even recognize how important it is and that they're being judged on the email that they sent to me.
Yeah.
And it's kind of amazing to me, but it's like just it's obvious that they haven't stopped to say what you're saying. It's like, wow, I'd like to be better at this.
Yeah. So how
But
does
they
that?
don't see a gap. To them, from a coaching standpoint, there's no gap for them. There's
Yeah.
no, they haven't experienced that there is anything missing that has them want to do better.
So then when you're doing reviews, I imagine when you're going out and trying to compare certain products or whatever it is, and you're reading these things that were
Right.
not just submitted but then approved, like
Mhm.
is it just really ambiguous language? Is it really it's just poorly written and it's just you're just rolling your eyes when you're looking at it? Like how does it impact outcomes in your industry?
Yeah, well, it makes it hard. Like, in the end, a poorly written patent is not going to stand, but very few get challenged to that point. So, like, really, as a more regular, um, on a more regular basis, it just makes things difficult for everyone to try and figure out what's there.
Yeah.
So, but ultimately, a poorly written patent is not going to stand. If someone really spent the money to challenge it, it's not going to stand.
Yeah.
So there's that.
So in this part of your career now, it looks like you're doing a lot of training, you're educating, you're getting the word out, you're trying to inspire folks as well. Like maybe describe to me like what are you out there doing, Rich? Like what's your why right now, man?
Yeah. What am I out there doing? My why right now is to kind of grow my audience sufficiently that I get more of the right clients in,
Yeah.
to grow my firm so that I could be less. Um, I want my role to be just creating relationships, really
Yeah.
creating relationships and overseeing a team. But that's kind of what I've been moving towards more.
That's a beautiful thing, man. And as you should, right? I mean, as far as putting so many years in the trenches,
Mhm.
getting after it, like this is a great opportunity. One to get asked by the American Bar Association to write a book on obtaining patents for consumers, and then two to just put the word out, try to help guide folks, and know that you're a wealth of knowledge to partner up with. So, where do people find you, and where are you most active?
Okay, where to find me? Well, if you want to learn about patents and trademarks, I have great resources on my website, which is goldsteinpatentlaw.com. And you could also get in touch with my team that way to see if it's a match to work together. You could, if you're into podcasts, then you can check out Innovations and Breakthroughs wherever podcasts are streamed. And then if you want to kind of, if you want to read about patents in plain English, then my book is the American Bar Association's Consumer Guide to Obtaining a Patent, or the ABA Consumer Guide to Obtaining a Patent. And you can find that on Amazon. And where would you find me? I'm at events very often, like in entrepreneurial world. I go to a good amount of mastermind events, and also in the Amazon seller world. I'm well known, and I speak at a lot of events there. I'm usually throwing a party when there's an event happening.
Hey,
So, yeah, that's me, and
uh,
hopefully I'll get to see you at one of these events one of these days.
100%, man. I'm all over the place as well, and I'm looking forward to figuring out a way to connect. As we wrap up here, I got one last question for you, which is 2022, man. What are you most excited for? What's the thing that you're fired up about the most this calendar year?
Oh, looking forward to the summer.
Yeah, summer's my time too.
Yeah.
Lake time, camping, boating, all that good stuff. I'm all about it.
Yeah, beach. Yep, 100%. Yeah, looking forward to the summer. I've got a lot of events coming up this spring. I think I have 20 flights booked between now and May.
Oh wow.
And summer comes around, and we'll be spending some time on the beach. Looking forward to the summer.
Well, Rich, I know that you're a busy guy. We played some email tennis here in order to find some time and get scheduled. And I appreciate your willingness to come on the show, and really looking forward to staying in touch with you and watching all the things that you post and put out there. Especially if you're an entrepreneur and you're listening to this podcast, definitely go find Rich online. And yeah, Rich, thanks for coming, man.
Oh, my pleasure, Jake.
Cheers.